Good morning. This is your Kelso Report for Thursday, February 23rd, and I'm your host, Clark Kelso. We got three more Supreme Court decisions today, first involving the Supremacy Clause, then qualified immunity, the third involving navigability. And then we have cases from the California Court of Appeal dealing with civil commitment, criminal law, civil procedure, and environmental law. So let's get started with our United States Supreme Court decisions for today. Now, sometimes the critical facts that set the stage for an appeal change while the appeal is pending. And if the changed circumstances don't moot out the dispute, the changed circumstances may at least change the legal issue to be resolved. That appears to be what happened in Douglas v. Independent Living Center of Southern California. The state of California had adopted a new plan for its Medicaid program which called for significant cuts in payments to providers. For a state plan to be legally effective, it must be submitted to the federal agency with jurisdiction over Medicaid, which is the Center for Medicare and Medicaid Services, otherwise known as CMS, and CMS must approve the plan. In California, providers and beneficiaries didn't wait for CMS to act, and they sued to enjoin the plan shortly after it was adopted by the state. The plaintiffs asserted that they had standing to challenge the state plan under the Supremacy Clause, with the substantive basis for their claim being that the state plan was inconsistent with the Medicaid statute's requirements for reimbursement. Well, the Ninth Circuit had affirmed the preliminary injunctions against the state that the district court granted. The Supreme Court granted cert to decide whether the plaintiffs could even mount a Supremacy Clause challenge to a state plan. However, after oral argument before the court, CMS approved several of the state's amendments and the state withdrew the remainder. With these changed circumstances, a 5-4 majority of the court decided that the legal issue had now changed to whether the providers and beneficiaries had standing under the Supremacy Clause to challenge a state plan that had been approved by CMS. Framing the issue in this way may dramatically alter the litigation context, since it appears now that if there is to be review of CMS's decision, that review should be pursuant to the deferential review processes of the Administrative Procedure Act, rather than a direct action filed in a district court. But the Supreme Court did not resolve that question in its opinion, preferring to remand to the Ninth Circuit to give that court the chance in the first instance to consider this new issue. Our next case involves the doctrine of qualified immunity. That was before the court in yesterday's decision in Messerschmitt v. Millender. The officers had conducted a search of the plaintiff's home pursuant to a warrant that was issued by a magistrate. The warrant authorized a search for all guns and all gang-related material, and it was in connection with an investigation of a known gang member for shooting at his ex-girlfriend with a pistol-gripped, sawed-off shotgun. The plaintiffs brought an action seeking to hold the officers personally liable for damages under Section 1983, alleging that the search violated the Fourth Amendment because there was not sufficient probable cause to believe the items sought pursuant to the warrant, that is, all guns and all gang-related material, were evidence of the alleged crime. The Ninth Circuit had held that the warrant was invalid on these bases and that the officers were not entitled to immunity because the invalidity was so obvious that any reasonable officer would have recognized it, despite the magistrate's approval. Well, what was so obvious to the Ninth Circuit was not quite so obvious to a majority of the Supreme Court, which reversed by a 7-2 margin. The fact that the warrant was issued by a magistrate raises the burden on the plaintiffs significantly, since the officers really should be entitled to rely upon the magistrate's judgment. On the gun portion of the warrant, the Supreme Court reasoned that it would not have been unreasonable for an officer to conclude that there was a fair probability that the sawed-off shotgun was not the only firearm the suspect owned. It would be reasonable to assume that the sawed-off shotgun was illegal, and given his gang membership and willingness to kill someone, a reasonable officer could conclude that there would be additional illegal guns at the house. On the gang aspect of the warrant, the victim had given the police the information about the suspect's gang ties, and a reasonable officer could view his threat to kill her if she called the police as related to his fear of disclosure of his gang relationship. And at a minimum, evidence of his gang ties could easily be relevant to the prosecution of the suspect. Ultimately, the majority concluded that even if the warrant were invalid, it was not so obviously lacking in probable cause that the officers can be considered plainly incompetent for concluding otherwise. Next, we have a case involving what constitutes a navigable waterway. One of the attributes of state sovereignty has been that a state holds title to the riverbeds under navigable waters within its jurisdiction. Under the so-called equal footing doctrine, when a state enters the Union, it gains title within its borders to the beds of waters that are then navigable or tidally influenced, subject only to the paramount power of the United States to control navigation for interstate and foreign commerce. By the end of the 19th century, the rule had developed that navigability meant navigability in fact. And that means the river must actually be used in its ordinary condition as a highway for commerce. The Supreme Court has historically assessed navigability on a segment-by-segment basis. Now that's the legal background. In the case decided yesterday, PPL Montana versus Montana, a dispute had arisen between the state and the owners of hydroelectric power plants regarding ownership of the riverbeds beneath those plants. The Montana Supreme Court ignored the segment-by-segment approach and held that because the Missouri River in general is a navigable waterway, all segments of the river were navigable and title in the riverbed belonged to the state. It imposed $41 million in damages for unpaid rent over only a 7-year period. Well, the United States Supreme Court unanimously reversed. When analyzed segment by segment, it was clear the hydroelectric plants were located on portions of the river that were not navigable because of the rapid drops in altitude and the presence of waterfalls and rapids, precisely the features that make the hydroelectric plants feasible. As Justice Kennedy noted for a unanimous court, the state may not enlarge what actually passed to the state at the time of her admission by trying to adopt a novel, retroactive rule for determining navigability. Next, we turn to the California Court of Appeal in a case involving civil commitment. The defendant in People v. Sanders was committed to a 2-year term as a sexually violent predator pursuant to a judgment entered on a stipulated agreement. The defendant then tried to appeal, claiming that there was excessive delay in resolving the matter and the stipulated agreement was otherwise invalid. The Second District Court of Appeal held that because the defendant admitted to the allegations contained in the petition and did not condition the agreement on the right to appeal, he waived his right to appellate review of any alleged due process violation. Next, a case arising under the criminal law. Section 464 of the Penal Code provides that, quote, any person who, with intent to commit crime, enters any building and opens or attempts to open any vault, safe, or other secure place by use of an acetylene torch or any other similar device capable of burning through steel, concrete, or any other solid substance is guilty of a felony. The defendant in People v. Cardwell was convicted under Section 464, but the facts were that he used an acetylene torch to gain entry to the building. He did not use the torch to gain entry into a secure place inside the building. Relying upon the plain meaning of Section 464, the 4th District held the conviction must be reversed, since the statute proscribes using an acetylene torch to gain entry into a vault, safe, or other secure place, and that is expressly conditioned on the fact that the defendant has already entered the building. The prosecutor had the defendant on the burglary, but he overcharged by accusing him of violating Section 464. Next, an issue involving civil procedure and challenges to judges. Section 170.6 of the Code of Civil Procedure permits one side of an action to disqualify summarily an assigned judge based on a sworn statement of the party that the party believes the judge is prejudiced against that party or the party's attorneys. If the statement is filed within 10 days of the judge's assignment to the case and is in proper form, the judge has no discretion to refuse the challenge. The limitation to one summary disqualification per case applies even where there are separate proceedings, so long as the separate proceeding is merely a continuation of the original action out of which it arises, and it involves substantially the same issues as the original action. Well, in Pickett v. Superior Court, the Superior Court held that a second action filed by a different plaintiff against the same defendant, based on the same claims, but which sought slightly different relief, was a continuation of the first action. And since the disqualification motion had already been filed in the first action, the Superior Court rejected the second 170.6 filing. The Second District reversed, because the second action did not actually arise out of the first action, and it was not a continuation. Instead, it truly was a separate action, with a different plaintiff seeking different relief. In these circumstances, the plaintiff was entitled to its 170.6 motion. Next, an environmental law case. The city of Redondo Beach had amended its local coastal program. Shortly after that, a charter amendment was approved which required any major change in allowable land use to be approved by the city's voters. The plaintiffs brought a petition for writ of mandate against the city to require it to put the local coastal program amendment to a public vote. The city first argued that the amendment predated the charter amendment and thus was not governed by it. The trial court agreed with the plaintiffs and ordered the city to place the amendment before the voters. Although the city appealed, it also voluntarily complied with the court's writ of mandate. On these facts, the Second District held the appeal was moot, since the defendant had already complied with the sole relief sought by the plaintiff. The court affirmed an attorney's fees award in favor of the plaintiff. And that's it for today's Kelso Report. Have a great day in the law.